let's interact. This is good. That's what's great about this crowd. It's very interactive. So if anybody has any comments or thoughts or questions, throw them at me. And I'm very glad there's at least 2 other lawyers here, because the probability that I will need to be corrected is pretty high. So if I need to be, let me know. Throw it at me. So let's see. I did graduate from law school in North Carolina in '92. Graduated college there in '85, and I was actually in the very first game in that building. It was actually against Duke in 1986. So it's about time for that building to be torn down and a new one to be built. I clerked for a federal judge, a magistrate judge in the Eastern District of North Carolina for a year. Saw a lot of criminal cases there and discovery issues. Then I went to work for an insurance defense firm, not very glamorous there at all. But my boss, because I was back when I was a young and didn't have a gray beard, I didn't have a beard at all. My boss wanted to get into criminal cases, and since he was my boss, guess what that meant? I got into criminal cases as well. And eventually was on the appointed list for federal indigent defendants in the Eastern District of North Carolina and the Middle District of North Carolina and on my county, Guilford County of North Carolina, for state cases. Also, I got involved with doing death penalty appeals. And the highlight of that was, well, the highlight of anything I've ever done is I got to argue before the North Carolina Supreme Court on a death penalty case, and we won that case. So that was pretty cool. So I've been in the courtroom on these things. I've dealt with the state on these issues, and it's the reason I don't like to do those anymore. But I am familiar with it. And with how many people have seen the Making a Murderer miniseries on Netflix? All right, good, because I'm going to try to make some points back to that and reference it, and if anybody's got any comments or questions about how things apply to that Making a Murderer case, we'll tie it in. Because I think a lot of people were shocked by that. Shocked about how the state acted. And for those that don't know, it's primarily about a guy named Stephen Avery up in Wisconsin, rural part of the state. And he did 18 years for a sexual assault that he was later exonerated for. He did not do it. And as part of that, I thought Justin was waving at me, he's just taking a picture. As part of that, what we found out was that in that case where he was exonerated, after 18 years on the sexual assault, that the actual guy who had done it went on to commit other sexual assaults and eventually got put in jail. But if the police and law enforcement had honed in on him originally, at least 1 or 2 other assaults would not have occurred. And this is how politics comes into play when you're dealing with the state. Because if you get charged with a felony, particular felony, a misdemeanor to a lesser extent, because the penalties or the possibility of incarceration isn't as high, you've got the entire apparatus of the state trying to prosecute you. And we saw that in the Stephen Avery case. And he was not, this guy wasn't a Rhodes Scholar. He had some problems. He had some problems with the police in the past. But I don't think many of us in here are Rhodes Scholars. Maybe some of them haven't had any problem with the police. So what happens to people like Stephen Avery can happen to anybody. And that's one of the reasons I did really like doing criminal defense, because people will always come up to you, I'm sure you all can imagine it. How can you represent somebody you know is guilty? Well, first of all, the assumptions in that question are wrong. And we'll talk a little bit more about that, because you're innocent until proven guilty beyond a reasonable doubt. So everybody I represented at the beginning, until they were convicted, was innocent. And something that's very important to me, I don't think I brought my copy, but it's the Constitution of the United States. And so anytime you represent somebody who's been charged with something, even if it appears that they've done it, what you're doing more than representing that individual, which you are doing, you are making sure that the government, the state, abides by the rules in the United States Constitution. Because as you can see from that Stephen Avery case, they don't give a shit about the Constitution. And if we don't protect it amongst the people that we know are guilty, that just moves that battle line a little bit closer to those of us who are innocent. At least in a given case might be innocent. Because who of us really is completely innocent? Now, yeah, thank you, Ron. A metaphysical joke, exactly.
I feel like. Yeah. This is the energy.
Couldn't agree more. And And so, and I think people are so, they just don't know what's out there because most people don't have to deal with a federal charge. And I actually was able to, I spoke to a group of fifth graders this afternoon, my daughter's class in fifth grade, because I was asked to talk about some of the foundational documents or historical documents that led to our founding documents, the Declaration of Independence and the Constitution. So I had to go back and look at Magna Carta, English Bill of Rights, and all that type of thing. But when we got up to the Constitution that we currently live under, and I told these fifth graders, so they're about 10 years old in that range, and I said, well, part of this is that you have the right to not incriminate yourself, which means you don't have to speak. If a police officer asks you a question, you do not have to answer them. The look of surprise on about half these kids' faces was shocking. And so, if I did nothing else today, or in my life, I told about 30 kids that they do not have to talk to the police. And I may get some complaints from parents tomorrow, I don't know. But
tell them to get an attorney.
And the other thing I told them, because these are kids, I told them, and if anybody, any authority figure, law enforcement officer, starts asking you questions, you demand that your parents get present. You do not say a word until your parents are there as a kid. Recording. Yes, exactly. Right. So, and that ties into Steve Avery's nephew, Brendan Dassey, right? Who was he, what, 10th grade? Yeah, in that range. Yeah, he was a teenager. Right, yeah, oh yeah. And so, part of what happened to him, for those that aren't aware of it, well, first of all, we'll talk about the crime. So first of all, Steve Avery, 18 years, crime he didn't commit. The police focused on him because they didn't like him. I mean, he's a small community. The police knew who he was. They didn't like him. And so they focused on him because he had some run-ins with some people in the police department or the sheriff's department, because he was in the county. He's even more rural than whatever the city was. And, yes, sir.
I was going to say, I wasn't one of the people that he had a run-in, not an actual police officer, but
I guess sister
who was married to his...
That's right. That was one of the problems, yeah. So somebody who was related to the sheriff's department employee and an officer had some run-ins with this guy before. And Steve Avery probably, was an asshole, probably. But he didn't commit a sexual assault. And because they wanted to get him so badly, they let the real guy go, who was involved in a series of sexual assaults. He was eventually released because of the work of the Innocence Project and because of the advancement in DNA technology. So he was able to get out of that. But they also convicted his nephew. They lived in this compound. They had a junkyard, basically. Joel.
Well, there's kind of a step there before they convict the nephew, because what had happened is he went to actually sue the police department after being released, and then that's when the so-called murder happened that they then tried to implicate his nephew in. So there was a chain of events where he went to sue them, and then all of a sudden this body appears, and then
right, yeah, right. That's so.
But he threatened their money, and they were willing to kill other people to protect it.
That is certainly what a lot of people think happened. I don't know what happened, but it's certainly plausible in that case. And because, so yeah, he got out after 18 years, and so he had a civil lawsuit against the county and some other law enforcement people for wrongful conviction. And so now, if they didn't like him before, they certainly don't like him now. And that's when this murder took place. Murder did take place. I mean, a woman was murdered and burnt in a fire pit. So that's not a doubt. But just like there was a sexual assault before that he didn't commit, there's an issue, did Steve do this? And it was on his property, or the property in which he lived. They had like an Avery compound with this junkyard on the property. And his nephew lived there with his sister. And when this new charge came up, so this lawsuit is still pending. He settles it because the value of the lawsuit has been hurt a little bit. I mean, he was still wrongfully convicted. And so he settles it. I think he got $350,000. It was something in that neighborhood. The original lawsuit was filed for like $36 million. But whenever you hear somebody suing for $800 billion, that means nothing. It's kind of like an NFL contract. If it's not guaranteed money, that rest of it doesn't mean a thing. So you ask for whatever, and he eventually settled it for $350,000.
Now, he needed a lawyer.
Exactly. And that's, you guys are way ahead of me. You guys are way ahead of me. Because he wanted the best lawyers he could get. He hired 2 lawyers. He got some recommendations, hired 2 lawyers, one of whom attended the University of North Carolina Law School.
Was it a hot one?
I think it was the hot one, yeah.
Megan, put up the sign. Put up the sign. There it is. Yeah.
So Steve was able to hire 2 private attorneys, and his nephew was not able to do that because his nephew didn't have hundreds of thousands of dollars that he just came into. And one of the eventually, when Steve was convicted, and there's all kinds of irregularities or odd things that happened in his case, and I've probably forgotten some of them, so we can get into some of those in a minute. But when he was actually convicted, he was convicted of murder, guilty of illegally possessing a firearm, but he was found not guilty of mutilating the corpse. And the corpse had been burned up. I mean, this is kind of what it is what we refer to as an inconsistent verdict. How can they find him guilty of the murder but not guilty of mutilating the body? And that happens a lot, not just in criminal cases, but even in civil cases it can happen. So you really got to, what is going on with the jury back there? Do they think that, well, we're not positive, so let's kind of compromise. We'll convict him of the murder, but not of the mutilating the body.
Well, we had that juror that recused himself due to health issues,
Right.
supposedly. Right. What kind of tomfoolery took place there?
Remind me what, because he was only in the jury. One of the original jurors excused himself because he was allowed to be excused because he had some family issues that they never talked
and once
about.
again, it's pure conjecture, but
Right.
there was a correlation in between there being a hung jury and then this gentleman leaving, and then all of a sudden that being able to come back with a verdict in a relatively short period of time.
He also reported that the initial count was highly in Stephen Avery's favor.
That's right.
That only 4 people was guilty of the entire jury.
Right.
That's right. Yeah. So in that first vote, most of the jury was in favor of not guilty, of an acquittal. After he left, somehow they got all 12 of them to say he was guilty. So that type of thing just really kind of makes you scratch your head. And we talked about nullification, and I've talked about that before. And that's why, I mean, I love nullification. I'm all in favor of it. I tell people they got the right to do it. I think jurors should be told in the instructions they have the right to nullify. But what's scary about it is if you're a defendant, you have to wait all the way through the entire process to get to the jury, and then the jury has to decide to nullify. So you're putting your entire life, depending on, in a case like this, the rest of your life in jail, or potentially the death penalty, on the jury deciding to nullify in your favor. So it's not really I don't think it's plan A. It might be, if you go that far, it's something that I think is very valuable and a good thing to do. But even if people understand it, and even if we tell people that they can nullify the verdict, which I think they should be able to do, that's like the last line of defense. That's it. So it doesn't solve the problem of all this police misconduct. It doesn't solve the problem of stupid laws like the drug laws and some of the firearms laws, because they will still charge you with all of that. So I love it, but it's not a panacea to the problem. Now, a number of the things that the state did were suspicious, and here I think is a good contrast between Stephen Avery's 2 private attorneys with a lot of experience, very good, dedicated attorneys, and his nephew's appointed attorney, his first appointed attorney. Now, the nephew, Brendan, was very close to being learning disabled. He's a teenager, he's not smart, does not have a high IQ, very socially awkward, let's put it that way. And so the police are trying to get him first to testify against Steve, because he lived in this compound, not far away. And they're trying to get him to implicate Steve, and at the same time implicate himself. And this is all online. You can watch. There's like a 60-minute version of the interrogation.
There's a 6-hour version actually out there that shows like the whole.
There were multiple interrogations, right? So you can check this out, and this is what is really offensive and really obscene if you watch this, because the kid clearly has no idea what they're talking about when it comes to this murder. No idea. And so they keep telling him, tell us the truth, Brendan, tell us the truth. And at first, I have no idea, I don't know what you're talking about, what do you mean? And then they say, well, we know what happened, Stephen. I mean, we know what happened, Brendan. We know what happened. We know that Stephen killed this lady. We know that. We know that. First, they didn't know that. And that's another thing to remember. It is constitutionally allowable for police to lie to you. So they can say, oh, we know all your buddies have already said you did it. That could be a complete and blatant lie.
Why is that?
Because we live in a police state.
No, that's not the reason.
Well, there's a constitutional loophole.
Right, it's a Supreme Court ruling. Right, the Supreme Court has said. Oh yeah. The Supreme Court has said that that's just an investigative technique.
Is it a First Amendment issue for the cops? Like, could they get charges pressed against them for libel or not libel?
No, they have immunity.
No. No. And because and Stacey's right, it does go back to immunity. And as I was telling these fifth graders earlier today, back when we had a king, the king had divine right. The king was there because God wanted him to be the king or the queen. So the king or queen could do no wrong. So if his carriagemen ran over you and killed you, the family couldn't sue the king because the king could do no wrong. And that concept of sovereign immunity still exists in the United States today. Now it's cut back. Legislatures have cut it back. But for example, in Colorado, if the state does run over you negligently, or somebody in a police car or a fire truck or whatever it is for the government runs over you and maims you for life, the legislature allows you to sue, but there's a cap on how much money you'll be able to get. Whereas if just Donald Trump did it, there would be no cap. So that's a vestige of this idea of sovereign immunity, and it goes to the police as well. But DAs as well, prosecutors, are basically immune from prosecution. Now that is cracking, and we have had some DAs recently sentenced for their misconduct in prosecuting people. Now you can be disbarred, the lawyer could be disbarred for misconduct, but there would be no criminal sanction. But that is becoming more frequent. So in this interrogation, this teenager doesn't have his parents present, or his mom. His mom would be the one that would be there. He doesn't know enough to demand or insist that his mother be there, or that he needs a lawyer, because at this point the police are just buddying up to him. Just tell us what you know, Brandon, that's all we need to know. And when he's not admitting to being involved in this murder, because he wasn't, they start asking him, well, weren't you involved in this murder? Didn't you see Steve kill this lady? Well, what did you do to her? And at one point, they even asked him, what did you do with, I think it was scissors or a knife? I think it was a knife. What did you do with that knife? What did you do to her hair? Yeah, what did you do to her hair? And he has no idea. So he says, we cut it. That's not the answer the cops were looking for. Not the answer they were looking for.
Her head. Yeah.
Right, what did you do to her head? What did you do to her head? And he said, we cut her hair. And the cops went, no, that's not the right answer. But I mean, they didn't say that, but you can see that's what they're thinking. So they say, did you cut her throat? And after a while, this kid's like, and they're telling him, if you tell us the truth, everything will be okay. Just tell us the truth. Everything will be fine.
And he thinks he gets to go back to school.
Right. Yeah, he was taken out of school.
He's got to hand in a project.
Exactly. So after and so they say, did you cut her throat? And they say, tell the truth. He says, yes. And you're watching this, it's clearly he's just saying it. Yes. You guys want to help me and you want me to tell the truth, and you're asking me if we cut her throat. Yeah. I mean, it's so obvious that he's trying to he's telling them the answer that they told him to say, so they'll be happy. I mean, you like to think most people wouldn't do that, but this is an almost retarded kid. And this happens a lot, where they want to just be able to go home and get out of there. He's been in there for a long time. He hasn't seen his mom. He hasn't seen anybody that is friendly to him. So you watch this, and it is absolutely and completely obscene that these cops do this to this kid. And that was the basis of his conviction. Because there was no other evidence. None. No other evidence. And so yes, ma'am.
I have a question. You can finish thoughts.
So, coming back on my tangent, Stephen Avery was able to hire great, dedicated, hardworking attorneys. Brandon was not. And when when Brandon's attorney saw the confession, only thing that was in his head was, well, we just got to cut a plea. You confessed. That was the only thing in this guy's head. He didn't think about suppressing the confession, didn't think about tacking, all of these grounds that you could have tried to throw that confession out. He just said, well, what can we do? You confessed. And that's all he wanted to do. So that's the difference, I think, between, in this case, the lawyers on each side. Yes, ma'am.
Okay, so Brendan Dassey's first lawyer, I think everyone can, for those who watched, can say that guy was fucked up and corrupt.
He just wanted him to plead. I don't think he's corrupt. He just, he looked at the evidence.
That's right.
Negligence, definitely negligence.
But my friend's the second lawyer. The second lawyer is the one who brought it to trial, and he's the one who oversaw the release of that interview that you're talking about. As someone who's worked in the law, what do you think about the fact that they didn't show the interview in its entirety? They cut it off before he asked to now I'm going to turn it back to turn this project, and they cut it off also. The jury never saw him tell his mom, they got in my head, Mom. I just told them what they wanted to hear. They got in my head.
I did what I did in school, I guess.
Yeah, I guessed at the answers.
Do you think he has any hope of an appeal based on the fact that they never showed the full interview to the jury? They didn't have any of that information? What's the rationale?
He's got a hope, but it's hard to win on appeals. Because you got an ineffective assistance of counsel claim for not insisting on that entire interview being played. And those are hard to win. They can't happen, but oftentimes, so in this case, whoever his appellate attorneys are will say, all right, that's ineffective assistance of counsel because they didn't do that. Well, at this point now, the state's appellate lawyers will go, that was just a strategic decision. Yeah, right. And so it wasn't, it might not have worked out for them, but that doesn't rise to the level of ineffective assistance of counsel. And appellate courts generally don't want to overturn a conviction. They will, but they're not predisposed to do it. Their bias is going to be to keeping it. Stacey.
I was just going to say, you have to remember that once you get to the appellate level, the onus is now on the defendant to prove that something was done wrong, right? As opposed to the state continuing to convict him, right? The onus is completely shifted.
The burden of proof is different.
Completely shifted. And they're already, he basically has to prove that had this whole thing been shown, that the jury would have come back with a completely different verdict. And judges are not likely to be like, oh yeah, it would have been a totally different verdict then. It's very rarely that the judge is going to say the verdict would have been different.
Right.
I have a question.
Yes, sir.
Didn't Brandon's lawyer actually hire an investigator who, it turned out, got a confession from Brandon with drawing and graphics about what happened, which was used against him in court?
Yes, it was. This goes back to that first appointed lawyer that he had, the lawyer who just wanted him to confess and cut a deal. Because it's easier to plea bargain than to try a case, for one thing. And plus, the guy just didn't have the right mentality. If you're going to be a criminal defense attorney, you've got to want to kick everybody's ass. And this guy was like, you confess, what am I going to do?
But that's an indictment on the system as it is anyway, that he has that attitude.
Oh, absolutely. No, you're absolutely right. Absolutely right. And so when he's trying to convince Brendan to cut a deal, plead guilty, Brendan at this point is going, I didn't do it. I made all that stuff up. I told him, I didn't do that. I just said that because that's what they wanted me to say. He won't cut a deal. So that first attorney hires a private, or has his own private investigator, or whatever his relationship is, and this guy videotapes. This is Brendan's lawyer's investigator, who's supposed to be helping the defense. This guy, it's even worse than what the cops did. He says, we know you did it, Brendan. We know you did it. So tell us you did it. Write it down that you did it. Draw a picture of what happened. And he drew this picture that had absolutely nothing to do with any evidence in the case. And he said that, we cut her throat, blood is everywhere. No blood was in the trailer. None.
Well, he made it do it 2 or 3 times.
Right, yeah, he kept, because all this investigator wanted him to do was to confess and cut a deal. And so he wasn't looking out for Brendan. Right. He was looking out for the lawyer who didn't want to try the case. who just wanted to cut a deal. And that was really horrible, absolutely. That was one of the worst things that his first attorney did, was to have this guy to do that, which was used against him. Now, in Avery's case, his lawyers pointed all this out, and the DAs in Avery's case knew that they were going to get killed if they tried to use the nephew's testimony, because he'd gone back and forth more than one time. A lot of problems with the confession. So they originally got all of the nephew's testimony, trying to use it against Avery. They had a press conference saying, we got all this new evidence now. His nephew said all his horrible things. They raped her, they cut her up, they did all these horrible things, and we're going to prove that. Well, by the time the trial rolled around, that was so full of holes, they couldn't use it. But they already went to the press. They told everybody in Wisconsin that this is what happened. And when it came time to actually do the evidence, they realized that wasn't going to work. They didn't use Brendan's testimony in Avery's case. And do you think they had a press conference about that? No. Do you think they said sorry to anybody? No, of course not. And here's an important thing about when things are stacked against you, when you're charged with any type of crime. Remember, district attorneys are politicians. District attorneys are elected to their office. Most of them want to be the attorney general. After that, they want to be the governor. No telling after that. They are politicians. And even a worse example of that, I mean, it's just an illustration of it. Back in North Carolina, where I practiced for 10 years, judges are elected. And so you've got, a competitive election for a judge position, trial judges and appellate judges, and they run commercials like they do out here for Congress or city council or whatever. They will have billboards and radio commercials talking about how tough on crime they are. So they're like, I'm going to convict everybody, I'm in favor of the death penalty. And so they're selling that because people are buying it. If they weren't selling it, or if people weren't buying it, they wouldn't be selling it. So it just kind of goes into that same attitude with the DAs. They're supposed to only be concerned about justice and finding the truth. And part of what they're supposed to do is in their investigation, when they've got the police and everybody else, if there's any evidence that might be exculpatory, it's the legal word, might help the defense, they are constitutionally required to turn it over. And I've got some stats here, and if we get to them, they don't do that a lot. They don't turn it over. And part of the problem is they get to decide that, at least initially. They get to decide, well, will this help the defendant? Nah, that's not going to help them. Now, and the only way that can ever be determined is if somehow after the conviction, some lawyer gets to look at that, say, hey, they should have turned this over. And I'll get the exact number here, but there's an incredible, out of all of the exonerations, and in 2015, there was more exonerations in the history of the United States since people started keeping these records. Government misconduct, either police or the DAs, was involved in a very high number of those. So don't trust the government.
2015 had more exonerations than any other year.
Yeah, and I've got the stat here, the thing here, I'll get to that in a second, I believe. All right. Oh, another thing you hear all the time, quite often, is, we demand justice for the victim. How many times have you ever heard that? Well, all I want to say to those people is, convicting the wrong person ain't justice for nobody. That ain't justice. I know that's not English, but I use that for emphasis on occasion. It's part of my local color. Yes?
To go back to what you said about how, for instance, in North Carolina, the judges are elected.
Right.
I mean, either way, it's either an appointed situation or an elected situation, so wouldn't elected be the better option?
It could be. There's arguments for it.
Okay.
Because in Colorado, you've got to have political connections.
Is there another option? Because, I mean, that
No
seems
judges
like a
anarchy.
tough decision to make in general. Like, I don't think there's any good option.
For voting for a judge?
Absolutely,
You mean?
yeah.
There's drawbacks and pluses to both sides. In Colorado, if you want to be a judge, you basically got to know somebody who knows the governor. You've got to have been involved in if not campaigns, friendly to campaigns.
I feel like that just makes the justice system just on track to begin with when you start with the top dog
Right.
in the whole system being elected elected or appointed in that way.
Ah,
And especially
yeah.
in the Avery case, I feel like the judge was so incredibly biased going into it. There was no way the judge was going to give him any sort of sentencing
break,
that
right.
would be...
Or any evidentiary break. Well, guess what most judges used to be? DAs. I mean, that's just a fact. Most judges used to be prosecutors. They used to be district attorneys. Yes?
So David, two real quick questions. You know, in light of what you just articulated, what's the tenor like here in Colorado, one? And secondly, if one was to go to one state out of all of the 50 and have the best hope of being able to have justice, what state would that be?
I have no idea.
Okay.
Sorry. Stacy smoked the whole. So, I mean, Nebraska. Sorry. That was like somebody saying I know what to do. Sorry.
But from a defense standpoint, Colorado's your best bet.
But what's the tenor like here in Colorado?
It varies from county to county, judicial district to judicial district, because each judicial district has its own elected district attorney.
Right.
And each county has its own elected sheriff. So all of those things determine, you know, how that justice system is going to be in that county. Of course, Denver doesn't have a sheriff, elected sheriff. Only one that does not. All right, let me hit a couple of things here, a couple of other kind of broader points, and I wanted to mention another wrongful conviction case closer to home, and that's Tim Masters in Colorado Springs. He was convicted as a teenager of brutally murdering a woman up in Fort Collins, and he did 10 years for this. And then again, DNA evidence eventually cleared him, but the two assistant district attorneys that prosecuted that case were later censured by the Colorado Supreme Court Ethics Board, whatever it's called, for, I'll get the quote, negligence while serving as prosecutors, for failure to turn over evidence that would have benefited Masters' defense. So that's what we're talking about. There's a Supreme Court case called Brady, and it's called Brady material. If there's something that might help the defense, you got to turn it over. That's part of your goddamn job.
So are they still prosecutors?
I'll tell you what happened. No, it's a great question. Here's the punchline. They became judges. But there's more. There's a little bit of justice. So they became judges, both of them, in Fort Collins. And this, after Masters was exonerated and was released, and they were censured for not turning over this evidence, the one thing you do have in Colorado is retention elections for judges. So every so often, I think it's 8 years, it might be less than that for trial judges, but you'll see in your ballot just about every time you get one, it says retention judges for elections. You want to retain or not of every judge listed. And 99% of the time, everybody's retained. When all this came out, there was a movement to not retain these two judges, and it succeeded.
Nice. Wow.
So, at least, yeah, so at least they were removed from their judgeship. At the very least, that's a good thing.
Wait, let's hold. Do you have only a few more points?
Yeah, let me add a few more points.
Let's hold off on Q&A.
So, the things that are, I'll tell you their names. The judges' DAs, Terry Gilmore and Jolene Blair, public record. So, it's good that they are no longer judges are involved in that regard. All right, things that are stacked against you. Misconduct. We kind of touched on some of that. And misconduct of police, misconduct of the prosecutors. Misunderstanding of reasonable doubt. Now, here's my favorite example of this, because I did drug cases in federal court for a while. You can go to jail for life in federal court for, say, dealing cocaine. If there's enough cocaine that they can convince the jury you sold.
There's never enough.
Isn't that the truth? Isn't that the truth?
All right.
Guess how much cocaine that the prosecution has to bring in and show the jury that you were involved with to get that life conviction? Zero. Zero. How could that be? All they need is somebody else to say you had that much cocaine and you sold it. And who are most of these people? Most of these people are either already serving time for some other drug offense, or they're one of your co-conspirators, alleged co-conspirators. And what do they get for their truthful testimony? Years off of their sentence. Even if they've already been convicted, if they truthfully testify, we know what that means, right? if they say what the prosecution wants them to say, let's say they might get 5 years off their sentence. Could be more, could be less, depending on the circumstances. Perfectly fine. Not a problem. Guess what happens if I go up to a juror, in a case I'm not even involved with, and I say, here's 20 bucks to tell the truth. I'm going to jail. So 20 bucks is illegal. 5 years off your sentence, no problem. Does that make any sense to anybody? And when I was young and naive, I'm like, all right, so here's a particular case. He's got 5 guys going to testify against him that he did X, Y, and Z. They're all getting time cut off of their case. Reasonable doubt. What jury in the world is going to convict this guy based on these snitches that are getting time off their case when that's all they've got? No way they're going to win that. Yes, I was wrong as hell. That happens every day.
Snitches get stitches.
And they get 5 years off their sentence.
Carmelo.
Get out early, apparently. They get stitches and they get out early.
Yeah.
So that's one of my, I think people misunderstand reasonable doubt, and that to me, that's an example of that. I mean, yeah, all right, I could have more examples of that, but be aware of what reasonable doubt means. Misunderstanding of the Constitution. Sometimes you'll hear, oh, defendants are always coddled. They get off on technicalities. And what people don't realize when they say that, I want to slap them with Constitution, is they say, oh, technicalities, you mean the goddamn Constitution? Is that what you're talking about? The one that protects your ass?
Every day.
And there's an example from a Spider-Man comic. I actually read this in the Legal Journal, but it was in the Spider-Man comic. Bad guy in a public square, hundreds of people around, kills somebody, everybody sees it, and he's arrested, and then one of the frames says, that son of a bitch was released because they didn't read him his Miranda rights. Goddamn technicalities, right? Well, that's not how it works. If you're not read your Miranda rights, anything you say after that, once you've been arrested and you talk, when you haven't been advised you don't have to talk, they can't use that. It doesn't mean those 100 people that saw you do it still can't testify. So that's just kind of a blatant exaggeration or misunderstanding of some of these constitutional protections. So the power of the state. So it's another thing that you're stacked up against. Even O.J. Simpson's trial team, probably, I mean, as far as I know, the best ever assembled. You know, he had tons of money, tons of famous, well-known lawyers. Johnny Cochran, Kardashian, unfortunately, and his kids. Lots of Barry Scheck. I think Dershowitz even got involved with it. I mean, you can't have a better team than that. They were still outnumbered by the resources of the state. They had the entire state of California, the State Bureau of Investigation, the LA County Sheriffs, the LA Police, whoever was involved. They had all of these state resources, and even O.J. Simpson was still outnumbered as far as resources go. The entire state of California versus O.J. Simpson. And O.J.'s rich, or he was. Not Steve Avery. Now what about the rest of us? We don't have those resources. So it's, the system is completely stacked against you in terms of resources. Investigations are so important and crucial. Most people can't afford an investigator, or they certainly can't afford an entire state worth of investigators. Faulty evidence is another thing that's stacked up against you. There are tons of articles about forensic evidence that has been debunked, but people are in jail based on that evidence. Some of that is hair microscopic examinations trying to say this hair came from that guy. Largely debunked, certainly not as, it's not like DNA evidence as far as reliability goes. DNA evidence has some problems too. Not if it's done correctly. But again, who is doing those tests on DNA evidence? Who's collecting the DNA? The state's collecting it. Who is doing the test on it? The state is doing the test on it. And in Avery's case, they had DNA. The state used it all up. So his defense couldn't do their own tests on it. I mean, that's just absurd. I mean, if it was my way and I could run the courts, I'd say, well, you can't use it then. You can't use that. If you didn't let them look at it, you can't use it. But that's not the way it is. The state was able to use that. Bite mark comparisons, bad forensic evidence. Shoe print evidence, bad forensic evidence. Bullet lead analysis, bad forensic evidence. Because people are still convicted and in jail on these things. And some of them have been executed. What's that?
Roadsides.
Yes, exactly. And why is this? And to me, I think it's because jurors want to believe the state. They want to have faith in the state. Because if they don't, I mean, then it's like, what can they have faith in? And very few libertarians get on these juries. And that's what is hard to overcome. That's another thing that's stacked up against you. You bring in some guy with a degree from the State Bureau of Investigation, says the MI evidence says he did it. Jurors want to believe that. Now, they don't always. It's true, they don't always. But they want to. And quite often they do. And all of these cases that were thrown out based on this faulty evidence is testament to that. And this type of stuff happens all the time. Now, at least lie detectors are not admissible in court. So from my perspective, don't ever take one. I mean, if it's a job thing, not criminal, it's up to you. But I would never, ever take a lie detector test. So, to close up, you are an underdog when you get arrested. You're an underdog. And frankly, it's a hell of a lot worse if you're black. There's numbers on that as well. So you do have a few things that are in your favor that a lot of people just aren't aware of. First of all, like I told these fifth graders, don't talk to the cops. Period. End of discussion. Never, ever, ever talk to the law enforcement people.
What was that?
Yeah.
Ever. Ever. Don't. They are not your friends. Fuck them. Right? And I didn't tell that to fifth graders.
All these fifth graders going, Mom, what is this?
I would have But I did tell them this. There is nothing more American than exercising your rights guaranteed under the Constitution. Don't let anybody ever bully you for exercising your rights. That is American to do that. So hopefully that got through to them. A couple more last points. So don't talk to cops. If a cop ever approaches you at a traffic pullover, at your house, whatever, record it. You record it. With technology today and phones, video's better. If you can't do that, audio it. Just record it. It's not illegal. You do it. And keep it. Yeah, good point. Yeah, absolutely.
So that if the cops break your phone, because they do that sometimes.
Yep. There are apps that will upload it immediately. So if you record it, it uploads to the cloud immediately. So if your phone gets destroyed accidentally, it's still available.
And make sure you have a password on it.
Right. What's that?
Have a password on it.
Yep. Have a password on it. Absolutely. I think would Periscope do that? Periscope uploads it immediately, right?
Sure. Yeah, there's a couple that actually. There's
ACLU has an app.
Yeah.
Yes.
That
go to your app store and
directly to them, and so
they
you
have
can access
right.
it from.
Right. All right. So don't talk to the cops. Record it if you do have to. Tell your kids to never cooperate. To tell them don't ever say anything until you get there. And you tell the cops they can get a search warrant or arrest you. I had a friend of mine. There was a horrible child dismemberment up in Westminster. They were going door to door at every neighborhood house and asking, can we search your house? Almost everybody said yes. I'll just stop there. But my friend had listened to me, and she knew not to let him in. They came back 3 times, and every single time she said, no, you're not coming in. So if that happens, don't be bullied, because I was there on 2 of these occasions. If they tried to, I talked to them one time. They tried to bully you. They go, well, if your daughter was missing, wouldn't you want everybody to try to help? And I didn't. This was several years ago, and I wasn't recording it, but I should have been, because this would have been great. I said, I want my daughter to grow up in a place where the cops don't bully her into giving up her rights. That's what I said. And I engaged them probably longer than I should, because I was kind of trolling them. But tell them, get a search warrant or arrest you. Come back with a search warrant, or arrest me right now. And if you get arrested, don't say anything until you get a lawyer. And if anytime they ever ask you a question, say something to this effect. I assert my right to remain silent, guaranteed under the 5th Amendment to the United States Constitution. Repeat that like a mantra. I assert, you can say, to be even perfect. Yeah, the Dave Chappelle, have you seen the Dave Chappelle thing? Look it up. Google Dave Chappelle. 1, 2, 3, 4, 5. I Out of all the amendments in the Constitution, my favorite one is the 5th. It's very funny, yes. It's even funnier when we don't do it.
And if you get pulled over, say over and over again in your recording, I do not consent to a search. Because
Correct.
if they start searching,
Yep.
and you're saying that in the video, it usually is not admissible.
And just one last point on that, on affirmatively asserting your right not to say anything. You would think that the Fifth Amendment right to non-incrimination means you just could just be quiet, right? Actually, the U.S. Supreme Court said that's not enough.
You have to say that you're exercising.
Yes, you have to say, I am exercising my Fifth Amendment right to be quiet. So you have to fucking talk to assert your right to be quiet. But that's what the Supreme Court has said. So that's why you affirmatively say it. And say it, that's all you say. Russ.
Didn't they rule that you have to give them a name? I was just
You don't
gonna
have
ask.
to give them, you don't have to give them your full name.
Do you have to identify?
No, that's good. Oh, this is the last thing. Last point is, if you're on a jury, take reasonable doubt seriously. Doubt everything, and if you have to, if it's appropriate, nullify it. Doesn't matter what they did. Nullify it.
Presume innocence.
Yeah, which is what the rule
Let's get
says.
our